We've kicked off now. Thanks, Karla.
Thanks, Leah. Welcome everyone joining. We'll get started in a moment. Right, our numbers are still going up, and we've got about 100 and plus registered, so we'll just give it another minute. Right, good morning everyone, and welcome to London Climate Action Week 2021, and this event, a conversation with Philippe Sands and Tom Burke on rule of law and climate change. We're really pleased that you could join us. We see this as a really important conversation, and as part of London Climate Action Week, you're joining tens of thousands of others in this important week where we seek to harness the power of London for global climate action. I'd like to briefly introduce Philippe and Tom and tell you about what we're going to do today, and then we will dive into the conversation. Philippe is a very well recognized, long-standing practitioner and professor in law at UCL and Harvard. He's recently chaired an international panel looking at a definition of ecocide. We'll talk about that as we go through. And Tom Burke is a similarly long-standing environmentalist, practitioner, leader, founder and chair of E3G, Third Generation Environmentalism. And I am Karla Hill, an associate director at E3G, and also an environmentalist and lawyer. So the conversation, a safe, livable climate is under threat. Rule of law is under threat in many places. How can these two sets of issues come together? Where do they intersect? We're going to explore some of the dimensions of that picture in terms of looking at rule of law and climate, and also then see where we might go. So our purpose really is to get to what is the conversation between different communities engaged with rule of law and climate change, and what does that look like? So that's the destination. The journey has a few different dimensions, and before we move into that conversation, just a few housekeeping notes. You'll see in the chat there some instructions from my colleagues, so have a look there. We will be live tweeting this event. If you would like to join the conversation on Twitter, it's hashtag LCAW Alcor 2021. We will also record the event, and it will be available on the E3G YouTube channel now in the live stream. Welcome if you're joining us there, and after the event. We will also have time for some questions from the audience via the Q&A function on the webinar later. So feel free to make a note of any questions, and we will open that up and take your questions later. So to the conversation. Philippe, I'd like to turn to you first, and really to start with, so rule of law and climate change, what have they got to do with each other, and really what happens to rule of law in the face of climate change?
Firstly, I mean, the rule of law governs all human activity from my perspective at the national level and at the international level. In relation to climate change, it became an active engagement only right at the end of 1989. I was actually yesterday with an old friend and academic, Dan Bodansky, who's written extensively on climate change, some wonderful pieces, and we were reminiscing back to our start in this area. I was at the Second World Climate Conference in 1990 and heard Margaret Thatcher address the need for an international convention to deal with climate change. That was amazingly more than 30 years ago. And at that point, in a formalized sense, the process of an interconnection began. And reasonable people will agree or disagree as to how much progress, if any, has been made over the last 30 years. But the rule of law implies the idea that human activity that has impacts for our climate system is subject to certain limitations in our rules of positive law, whether they are domestic law, conventional law at the international level, or possibly customary international law. It might be in relation to tort, it might be in relation to civil law, it might be as ecocide, as an idea gets off the ground, the criminal law. But I don't think anyone today would seriously doubt the proposition that human activity, statal activity, corporate activity, private activity, is subject to constraints imposed by the law at the national and international level. Where reasonable people disagree is the direction of travel going forward. And I think that is now the debate. What does the rule of law mean in practice in relation to climate, not whether there is a rule of law?
Thank you, Philippe. And I think we'll pick that up. Tom, I just want to spend a little bit of time, and Philippe, I'm interested in your thoughts also. Tom, in your recent speech to UKLA, the UK Environmental Law Association, you talked about feeling shocked at some point when this sort of esteemed legal community in London said that yes, of course, the rule of law is under threat. Why were you so shocked, and what do you understand by that?
Yeah, I should explain. I'm not a lawyer, so for this. At this occasion, a friend of mine, Richard McCrory, who was the first professor of environmental law, had invited me to a bencher's dinner. It was about 4 or 5 years ago. These are one of the formal dinners in the Inns of Court. And I went. It was kind of a very interesting thing for me to go and see the legal establishment at play, as it were. But what really shocked me was there was a conversation over the table at dinner between quite a lot of quite distinguished senior lawyers, all talking about what was happening to the legal system in Britain. So they were talking about the impact of cuts, the way in which the courts' times were being reduced, how long it was taking for people to get justice, the way legal aid was being, and that shocked me because it had never occurred to me. I've been involved in the environment for at least as long as Philippe and involved in these issues. And I just always assumed that the job was simply to extend the rule of law over the uncolonized area of the environment. It had never occurred to me that the rule of law itself was under threat. And what's happened subsequently is I've begun to see, not just in terms of are people simply investing enough, which is what I thought at the time, that if this was a correctable error, as it were, people were just not understanding the importance of investing in the rule of law. What I began to see over the last 3 or 4 years in particular, and take notice of, was that there are people who really are systematically attacking the rule of law. So we saw this in Britain when there was outrage at the idea that the law should constrain what the government wanted to do. And what really shocked me about that was it was lawyers who seemed to be leading some of the loud voices, accusing judges of being the enemies of the people. So that started to really wind up my concern. And the one thing I'm very alert to, having worked on climate change literally since being in the room when the Framework Convention on Climate Change was signed, what's concerned me is if climate policy fails, there will be chaos, social chaos, political chaos, economic chaos. And in that chaos, the rule of law will be, cannot survive. So there seemed to me to be quite an interesting and important interaction between those people who, as lawyers, want to see, or not just lawyers, I mean, as citizens, want to extend and protect the rule of law, and those people who, as environmentalists, are very focused on protecting the environment, in particular climate change. And I can't see much of a conversation yet going on between those two communities, hence my speech.
Can I just come in on that, because I just want to reinforce what Tom is saying. I join with those lawyers sitting on the tables of Inner and Middle and other temples who are deeply concerned about what's happening in the United Kingdom. You mentioned the headline in various newspapers, which was spun by 10 Downing Street, enemies of the people, just 3 Court of Appeal judges who were just doing their job and seeking to apply the law to the question of Article 50 of the rules relating to withdrawal from the European Union, nothing more than that. But it goes beyond that. And I just want to be very careful. I'm not here making a party political point. You'll know, Tom, that I was on the front lines back in 2003 when a Labour government waged a wholly illegal war against Iraq. And so what I'm about to say is not party political, but we've never had a government quite like this one, which has been so brazen. In 2003, the then government at least tried to make the argument that the use of force in relation to Iraq was lawful. It was a misconceived argument, but at least they tried to frame it in that way and go beyond paying just lip service to the rule of law. This current government doesn't even do that. Let me give you 2 examples. Firstly, this is the first time, as far as I know in history, last autumn, that a government has laid before Parliament a bill which on its face violates a treaty obligation of the United Kingdom. This is in relation to the Northern Ireland Protocol on the Brexit withdrawal agreement. That has never happened before. And secondly, and I disclose an interest because I'm counsel for Mauritius in the proceedings at various international courts on the territorial sovereignty of Chagos, the British Indian Ocean territory claimed by the United Kingdom, Britain's last colony in Africa. The International Court of Justice gave an absolutely decisive and basically unanimous decision in 2019 that Chagos belongs to Mauritius, not the United Kingdom. And a Tribunal for the Law of the Sea judgment binding in January of this year ruled the United Kingdom has no claim to the Chagos archipelago. What has the British government done? It has stuck 2 fingers up at both international tribunals and the General Assembly resolution. This is just utter lawlessness on the international plane by the British government. And so if we ask the question, what is the genuine commitment of the United Kingdom to addressing climate change through international rules, I would say you cannot trust this government at face value for what it says is its commitment. Now, I hope it changes. I hope future governments, be they Conservative, Labour or other, will genuinely embrace a rule of law approach. But this lot, I would not trust them further than I could throw them. And you see that clearly in a decision, you know, to mouth off on all the importance of COP26 on the one hand, and then give the green light to a new coal field in Cumbria in the same breath. I mean, it's absolutely staggering.
Thanks,
Well,
Philippe, and thanks, Tom. Tom, did you want to respond to that? And then Tom, I want to come in also on the next bit of the conversation is then, I mean, Philippe's kind of led in with it of why do we need the rule of law to respond to climate change and to make the kinds of transitions that we need to make, the sort of whole economy, whole society piece?
Precisely because of that, it is the biggest ever change in the way societies do things that humanity's ever tried. The consequences of failure of that attempt are enormous. And we're getting our preview of that, looking at what's happening in Canada at this moment. If you don't like climate change, the trailer that we're seeing in Canada, you sure as hell won't like the full movie when it comes. And what the science is increasingly telling us is that we won't, that the change that we're precipitating is happening faster than we thought, and the consequences are more dramatic. So in a way, if we're going to pull societies together, both inside nations and between nations, we have to have confidence in what everybody's going to play their part. Now that's, in effect, I'm not the lawyer to articulate it in the correct way, but in effect, that's what the law does. The law gives you confidence that other people will play their part. People do not obey the rule of law by and large, even ordinary criminal law, because they're afraid of getting caught. What they do is because there is a deep cultural commitment to doing it, as we saw with COVID in many other countries. People obey the rules because they see the value of it. And I think that's the piece that you have to buttress that. And simply, if you like, what we do when we make laws is encode that behavior that's in all our interest to share. And so the rule of law becomes really important as we try to go through this extraordinary change. We can't have people feeling that somehow there's one law for leaders or this country and another law for everybody else. So the rule of law becomes central to that extraordinary effort as we change the way in which we go about improving our business. And if you like, it comes down to a really core human value. It's an argument of the difference between freedom from and freedom to. Climate change is about how you draw the line between one person's freedom to burn all the fossil fuels they want and the rest of us, our freedom from the droughts, fires, tempests, and all the chaos that will be caused by climate policy failure. Now, the law is how we balance between freedom from and freedom to. So it becomes a central part of how we actually tackle climate.
Philippe, did you want to add anything there? I mean, it's sort of, I think Tom's kind of extending and adding to the point that you made at the top in terms of rule of law is somehow sort of everything in terms of kind of an ordering effect within human societies. And it sort of goes back to the Mark Carney, climate change is a threat to civilization. It's a threat to rule of law.
Well, I mean, if you want to look at the evolution of the rule of law in international relations, because here that is essentially what we're talking about. I mean, like the pandemic that we're currently going through, which is imposing very difficult times for a lot of people, climate change is not a matter that can be addressed by any community or country acting on its own. We're in this together. That's what we've come to understand. So we need international cooperation. The question is, what is the form in which that international cooperation takes place? There is economic cooperation, there is political cooperation, there is diplomatic cooperation, and there is legal cooperation. It's part of the instruments we have available to us, and it is the one that directs certain normative forms of behavior. Our current international legal order dates back to 1945, and essentially a decision that was taken in the summer of 1941 off the coast of Newfoundland by two leaders, Franklin Delano Roosevelt and Winston Churchill, to reconstruct the international order on a rules-based system. And they did it in a document called the Atlantic Charter, which became the basis for what was the United Nations Charter, and which premised international cooperation, not just on diplomatic, political, social, economic means, but legal means. And it created an architecture. And that was the architecture on the basis of which the UN Framework Convention on Climate Change came into being in 1992. So we've got an international legal order, such as it is. It's imperfect, we know that. It's essentially premised on a consensual approach. People have to buy into it. They have to sign off on it. You can't impose popular international will on individual states. They have to sign on to it. And that is the complexity of the situation. And we've seen with climate change, the international rule of law is functioning, but it functions slowly and imperfectly, but it's there. And the Framework Convention and the Kyoto Protocol and the COP are all premised on a recognition, A, that we're in this together, and B, we need rules at the international level to determine how we function. But plainly, it's not enough. And the question is, how do we strengthen those rules?
Just to set the historical context in a way, the reason why those two leaders met in Newfoundland or off Newfoundland and saw the importance of that task of creating a rules-based order was because they had experienced the first half of the 20th century and the consequences of that. So there was an enormous political imperative to find a better way to organize relationships between states. However bad the first half of the 20th century was for everybody, I promise you, if climate policy fails, it will be a lot worse for a far greater number of people. So that foundation that was established there, by the way, also was part of the approach that led to the creation of the European Union, as in a sense that there are problems in which you have to pool sovereignty if you're going to solve them. If you're going to pool sovereignty, you have to agree the rules by which you're going to manage that. And that was a very important part of that development. What we've seen increasingly over the really over this century, is a real assault on that idea that you somehow are better off if you pool sovereignty. We're all better off if we pool sovereignty. And as Philippe said, you cannot solve the climate problem on your own. And just to emphasize the point he made about the Chagos Islands and the importance of what you do, you can't argue that other people should obey the rule of law when you're not obeying it yourself. And so it weakens Britain's ability to argue for a strengthening of the laws, global laws we have to manage a climate if you're not obeying the laws yourself. And you can't argue very convincingly for obeying international laws when you're actually undermining your own rule of law domestically. So these things fit together.
Thanks, Tom.
They do indeed. I mean, just anecdotally on the Atlantic Charter, summer of 1941, it is a wonderful text because in a curious way, FDR really pulled the wool over the eyes of Churchill. I mean, what the Atlantic Charter essentially is an instrument by which the Americans persuaded or caused the British to commit to doing away with their empire. That's really essentially what happened. And as many of you will know, just a couple of weeks ago in Cornwall, President Biden and Prime Minister Boris Johnson signed a new Atlantic Charter. And I think that Biden has pulled the wool over the Brits just as Roosevelt did that back in 1941. And Boris Johnson signed off on a document which is marvelous in terms of its commitment to the rule of law and a multilateral rules-based system, but of course is completely inconsistent with everything that Boris Johnson stands for, including leaving the European Union. The point that Tom makes is absolutely clear. I mean, those words that Boris Johnson has signed on to are already being thrown back in the British government's face around the world. The point that Tom makes is a powerful one. On the one hand, the United Kingdom totally ignores the law of the sea and international law in relation to Chagos, and then it points the finger of blame at China in relation to the South China Seas and says, oh, you're not complying with the law of the sea and international law. And the Chinese basically turn around and tell the Brits to fuck off, because basically there is utter hypocrisy on the side of the United Kingdom. And that is deeply relevant to what's happening with the London Law Week this week, because the United Kingdom positions itself as the country par excellence as committed to the rule of law. And I'm very sorry to say that right now in the United Kingdom, That is a nonsense. And for London to position itself in that way, frankly, is a disgrace, because it is becoming a serial violator of the international rule of law. And let us be honest about that and not pretend otherwise. There is a terrific legal system with terrific judges and solicitors and barristers. And there is a government right now that is hell-bent on dismantling it, limiting judicial review, limiting the scope of Britain's involvement in Europe and in global institutions, possibly even pulling out of the European Convention on Human Rights. So let us be honest about what is going on. There is a total dismantling by the United Kingdom of its historic engagement to an idea that it invented in 1945, the idea of the international rule of law. And it is supported by many people, and it is supported by many newspapers.
Thanks, Philippe. Okay, let's come on and talk about, against that backdrop, what do we do about it? I just want to come back on one point, which is around the kind of this point around, is the way forward to somewhat extend the rule of law to climate and to environment. And Philippe, I want to pick up on the sort of eco side and where you're bringing into the international order kind of proposal for a new legal definition, and I'm really interested just to sort of see where would you fit that in this conversation, one against that backdrop of kind of a disregard for international rules-based order, but secondly in relation to climate change, where you're dealing with a global problem of emissions and the kind of shared responsibility, collective responsibility we have to cooperate and to deal with that.
Sure. Well, let me turn to that. But can I just say, just looking at the Q&A, how fascinating to see a little note from Patrick Alley, who writes just a snippet of interest. My father was a cipher officer on HMS Prince of Wales, that ship that took Churchill to Newfoundland for the Atlantic Charter in 1941, encoding Churchill's messages. I would love to know, Patrick Alley, whether there is any record. Did your father keep a note? Did he write about it? I would love to see that. Was Churchill blissfully ignorant of the disaster into which he had walked in 1941 in terms of the British Empire? Eco side. So last week, we, as a group of 12 lawyers working with the Stop Ecocide Foundation, unveiled a definition of the crime of ecocide for consideration as being the basis for a possible amendment to the statute of the International Criminal Court. A word here, since 1945, there have been 4 international crimes, and they're all anthropocentric. They deal with the well-being of the human being, of individuals and groups. Crime of aggression, war crimes, crimes against humanity, and genocide. And the idea of ecocide is the 5th crime, and it's different from the others because it's not focused. This is key in answering your question, Karla, on the well-being of only human beings, but on the well-being of the planet, of the environment, of our ecosystem. And what we agreed by consensus, which I'm very pleased to say because it's a broad spectrum of views, the group of 12, for the purpose of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And then we've given a series of definitions. I won't bore you with them now, but we can come back to them later on if necessary. Does it encompass climate change? Absolutely, it encompasses climate change. Does it explicitly encompass climate change? No, it does not. Why not? So in the group, we had a long and very significant debate on whether we should list different acts or harms. And in the end, the view prevailed, and I have to say I supported the view that prevailed, that we should not list particular acts or particular harms, because if you start listing things, you will leave other things out. And by leaving them out, you leave the unfortunate impression that somehow harm of that kind or acts of that particular kind are okay and are not caught. And I don't think anyone in the world can come up with a complete list of all human acts that could possibly be caught. But there was a second reason, speaking personally, I didn't want to mention climate change. The moment you explicitly link climate change with the crime of ecocide, the ecocide proposal is dead, because governments will say, look, we haven't spent 30 years trying to negotiate rules under the Framework Convention on Climate Change. to come and have these characters come along, you know, on the side and draft some new law on international crimes on protection of the environment and criminalize all these things that we've been saying that we can do. There's a debate to be had on the relationship between this definition and certain acts. And then there's a third element. The reality is each and every one of us contributes to climate change. You do, I do, we all do, everyone on this call does. So what, are we all criminals because we commit acts that contribute to climate change? Of course, we're not all criminals. The question becomes, how do you draw the line? How do you determine when an act crosses a line into potential criminality? And that is a really difficult question, actually, and not a question that one can answer briefly or in a legislative text. Ultimately, it will be for prosecutors and judges to form a view as to whether the adopting of an act which is either unlawful or wanton, reckless, with disregard to the environmental consequences, taking into account potential economic and social benefits, does that cross a line? That's a very, very tough question, where one draws that line. And just to put it in very practical terms, this is concentrating my mind a lot. So one part of my legal practice, I do a lot of boundary disputes, particularly for developing countries around the world, in Africa, in South America, and other parts of the world. I'm acutely aware that those boundary disputes are wanting to be resolved in the maritime areas precisely to enable exploration and possible exploitation to take place, including in relation to fossil fuels. So the question arises, by participating in such efforts to delimit maritime boundaries where you know that is part of the purpose, am I contributing to climate change? The answer to that, presumably, is yes. Is my legal advice in making that happen, whether as counsel or arbitrator or international judge, engaging in an act which is lawless or wanton? Well, reasonable people will disagree. Some will say, yes, it is, and I shouldn't be doing that. And I think the simple point is that each and every one of us have to ask ourselves these tough questions. Are there some cases that I will no longer do as counsel, because to do so not necessarily exposes me to the risk of prosecution for being a climate criminal, but which I shouldn't be doing because it's not for the greater good? Or do I carry on doing that stuff because I'm conscious of it, and because by doing it, I'll be in some way able to influence the decisions that are taken in the future to limit emissions of greenhouse gases? These are really tough, complex questions, but they are questions of individual responsibility for each of us.
But they can't just be questions of individual responsibility. The common law develops, in a sense, the way human beings develop generally, by trial and error. You make mistakes, you try to correct them, you create, as it were, norms of behavior, and you codify those norms. And that's the way in which we've developed law. And that was fine when you weren't dealing with irreversible consequences. That's not good. So we need, and Philippe put his finger on a very important point. What do you do when the villain and the victim are the same person? So we need to do some innovation and invention in legal concepts to deal with the fact that we have to cope with irreversibility. We have to cope with intergenerational questions and intergenerational equity that we're not going to solve by trial and error and the normal ways in which we advance law. So there's some real challenges, not just to lawyers, but to legal thinkers, about exactly what are the concepts we need to address not just climate change, because climate change is just the most urgent and most immediate of a set of major existential environmental problems, including the perturbation of the nitrogen cycle, for instance, what's happening about persistent organic pollutants and the buildup, and you can go down a list of those things, all of which involve these questions where the offense is caused by the collective action of lots of individuals. It's not, and they are also the victims of their collective thing. So that's a challenge to legal concepts, as well as it is a challenge to politicians about how do you, if you don't have the concepts, the legal concepts, how do you create the rules by which you would apply those arbitrations of those sort of complex things. Otherwise, you're left in the position Philippe found himself in, of leaving it down to individual conscience. And I don't think 8 billion of tech-enhanced people are going to manage their future, in a sense, on the basis of some happy alignment of individual consciences.
Thanks, Tom. I wanted to bring in exactly the kind of extension of the rule of law also requires us to think about maybe some new concepts that might be missing in the international system or in our domestic systems. I think ecocide may be one of those, and Tom, you've mentioned some others. But it also, as we sort of move on in the conversation, and we'll pick up some of the questions that are coming through in the Q&A. Thank you. It's also, what is some of those things have to be invented before we feel the worst effects, and that's perhaps the difference that we face compared to those moments last century. How do we instigate that sense of urgency and purpose? And I suppose, Tom, maybe to land it in this conversation, what is the conversation that we need to have, or the action that we need to have between environmentalists and lawyers?
Well, yeah, and let me roll back the question you're making to where we were, in a sense, at the beginning of my sense of bafflement that anybody was attacking the rule of law. What we're discussing now is how do you extend not just the application of law, but the legal concepts that we require, that we're going to need to deal with the kind of future we're committing ourselves to. And my sense is there's very little awareness in the environmental community about this issue. So you have, if you have lawyers talking about the rule of law, the kind of broad response is going to be, well, they wouldn't they? I mean, so we're missing a voice in this debate. As I pointed out in the speech you referred to, there are 28,000 environmental conservation groups in the United Kingdom. There are 5 million or so members of environmental organizations. That's 5 times as many as all of the political parties put together. And they are not punching their weight on these issues. And they need to do more and get involved in these issues. But to some extent, if you don't engage with the existing, as it were, political conventions and conversation on these issues, you shouldn't be surprised when it ignores your issue. So part of what I think we need to have, as well as lawyers beginning to think through their role in this and coming up with concepts, we need environmental organizations, environmentalists, and all the scientists who've driven the climate debate to get much more engaged in saying that we need to support the rule of law in general, because we can't have a better rule of law if at the same time we're undermining our existing rule of law. There's a real challenge here for the environmental community as well as for the legal community.
Thanks, Tom. Philippe, I want to start to open it up to questions, and one that's there that was also on my mind, and I'm interested in your thoughts, is around climate litigation. And obviously we've seen, just sort of many decisions and cases emerging in the last few years, and even in the last weeks in the Netherlands and Germany and elsewhere. And I'm just interested in how you see that interacting, and how would you position that as a dimension of rule of law and climate change?
I think it's a really important development. I noticed just in conversations with folk who may not be part of that community that is particularly attentive to these issues. I've done a number of interviews on ecocide over the last few months, the idea of ecocide with, newspapers, for example, related to the business community, the Wall Street Journal, Fortune magazine, The Economist, the Financial Times. And it's really interesting. Every single one of them focuses on the climate litigation and judgments of courts. They all say, well, something's obviously happening. And I think this goes into a broader set of issues. What is the function of the law? And here I'm limiting what I say to the international level. I mean, I'm not starry-eyed about the law. When Lemkin invented the concept of genocide, when Lauterpacht invented the concept of crimes against humanity in the summer of 1945, they didn't expect that the adoption of international legislation criminalizing such acts would suddenly cause people to start behaving themselves better or end mass murder. They knew it wouldn't do that. And environmental litigation and ecocide and climate change litigation is part of the process of changing consciousness. And that change of consciousness then hopefully leads to legislative, executive, and judicial changes. So it's all part of a change that's taken place. Of course, the big question is whether it's being done in time. And many reasonable people, and Tom has made this point, have very serious doubts now. The law follows. The law does not lead, and international law in particular follows. My own view about international law is that it is not responsive to situations until disaster has struck. If you ask me what are the big moments in international legal change and consciousness, I think of 1815, Congress of Vienna, 1919, the Treaty of Versailles, 1945. In the face of imminent disaster, I'm thinking of the Montreal Protocol on ozone depleting substances, which at least proves that in certain discrete circumstances, it is possible to act. Things happen, but the examples are few and far between. And my fear is that it is only climate disaster that will finally cause us to do what is necessary. That's what history shows us. We cannot prevent, but we can respond once it has happened on the international legal order.
So what Philippe is doing, and I think quite correctly is saying that this is a problem for politicians. Politicians will need a lot of help from lawyers in doing it, but at the end of the day, this is a problem that only politicians can resolve. You have the whole history that he recounted was very interesting, because it was the memory of disaster that drove the adoption of new legal norms, new international relations norms. We can't afford to count on learning from climate policy failure. Climate policy failure is an irreversible act, which is exactly what was meant by scientists saying that this is an existential threat, not so much to human beings. Human species might survive, but civilization won't survive. It's what Mark Carney meant when he said exactly what he said was, and it was very discreet in what he said. He said, climate change is an existential threat to macroeconomic stability. And most people don't stop to think of what macroeconomic stability means. Well, the example we had of a threat to macroeconomic stability, which was nothing like existential, was the financial crisis in 2008. And we didn't like that very much, and we recovered from it. So what Mark Carney has done, by the way, which is hopeful in the sense of getting ahead, what the central bankers have done is set out to rewrite the rules by which capital is allocated. That's an enormous round of hope, because if we're going to make the energy transition, we're going to have to shift the way in which we currently allocate capital completely differently. And he set out at least to change those rules. So it's not beyond us, with the right sort of stimulus and the right leadership, to think of the kind of things we need to do to meet this problem, so we avoid having to learn the hard way, which is what Philippe's, in a sense, a kind of history was, how do we learn the hard way? And he's absolutely right. The law follows, it can't lead. The politicians have to lead.
Thanks, Tom. And thanks everyone for the questions. I'll try to sort of group them and put them to Tom and Philippe, and make sure we continue in the conversation sort of format. And there's a few questions, a couple of groupings. One, there's a few questions around ecocide, and we will also share a link. There's a further event this week specifically on ecocide. So if we don't answer all your questions, there will be another event, and we will share details for that shortly. There's a number of questions on the sort of the rule of law, and you know, from Ana Barrera in Madrid. Rule of law is not only in danger in the UK. What about, you know, Spain, Poland, and the trend undermining of independent judiciaries, but also of climate litigation emerging, and how can the rule of law respond there. Also around what happens, kind of the erosion of rule of law, I suppose, Philippe, really, when you have so many failures, at what point do you stop having rule of law, and can that be significant enough that you simply fail on that front? And then also in terms of EU respect for international law, a question from Nick Flynn on the EU's persistent non-compliance with the Aarhus Convention. So I'll stop there, and Philippe and Tom, please respond, and we'll do another group in a moment.
Tom, do you want to run first?
I've just gone on, so I'll try and remember. You'll have to remind me of all of the bits in that. The thing I said earlier in the conversation, I repeat, the rule of law is not a rule of text. That's the administration of the law. The rule of law is a function of the extent to which a society believes there are rules that everybody will follow, and that therefore you can expect everybody else to do their part, and therefore it's fair. And so if you attack, there are gross ways to attack the rule of law. Literally, you can do what has happened, as one of the questioners pointed out, in some countries. You can literally throw out your existing judges and only appoint people you like to the judiciary. You can corrupt the rule of law in that way. But there are much subtler ways in which you can do it. If what you do is you don't fund your legal system to the extent that people then spend a very long time waiting to be declared innocent by a jury, or you don't fund legal aid so that only rich people can get access to justice enough, then you're undermining the rule of law. Now, what's clear to me is there are some political instincts that understand very well they're not going to succeed in attacking directly the rule of law in a lot of the, for instance, G7 countries, but they can achieve the same effect by taking away the ability of the law to deliver certainty of outcome and justice to people. And so I think we're seeing an increasing amount of that stealth attack on the rule of law, some of which is simply neglect, but some of which is malign. And I think we have to be very alert to the signs of this, because it is, at the end of the day, the rule of law is a web of expectations. So it's like an ecosystem. You know, you can damage the ecosystem to the point at which it collapses, and you don't necessarily always know that you're doing that damage. That web of expectations is what allows us, as it were, to protect our freedom from things that will damage our interests. And we've got to protect that web. And I wish, as I said, I wish environmentalists had a better understanding of that ecosystem that at least matched their understanding of natural ecosystems.
Thanks, Tom. There's Philippe. I don't know if you want to add anything there, but I might move us on to another question on sort of the international and national play, and is what we really need, especially now we have Paris, a greater practical action and national response. So in other words, a kind of an implementation and a response to what is in place at the international level.
I mean, the big issue, I think, really putting this in its broader context, is what is the genuine willingness of different countries around the world to engage with legal developments at the international level. I've touched on the historic place of the United Kingdom and the United States. And what we've seen recently is Make America Great Again and Brexit are essentially about a retreat from the idea of an international rule of law and international legislative agenda, including, frankly, for climate change, because that's just part of the general order. But if we move beyond those two countries, I mean, the United Kingdom is now in effect a bit part player internationally, and even more so having withdrawn from the European Union, really doesn't matter very much anymore. The United States remains extremely important And the current administration has sought to re-engage, but there's a very big question with Mr. Trump waiting in the wings. How sustainable is that engagement over the long term? There must be doubts about that. But looking beyond, we of course must look at very significant countries like Brazil, India, China, South Africa, and many others. And of course, their own situation is extremely complex. China has engaged with the international regime on climate change, whilst at the same time embarking on a raft of new projects to develop coal fields and coal mines, flatly inconsistent with a serious commitment. India too, I mean, faces tremendous poverty, and the issue of climate change is to be balanced with the need to feed and look after the well-being of a huge population. In Brazil, a country that has historically played a very significant and positive role on developing a climate change rule of law, currently has a president who thinks climate change is a nonsense and is perfectly happy to destroy the entirety of the Amazon in the name of economic growth. So I must say, it looks pretty problematic, I would say. And the prospects for real change do not appear to me to be imminently on the horizon. And I must say, having lived through the climate change negotiations and watched what's happened subsequently since 1992, I'm not hugely optimistic that COP26 is going to produce any sort of a breakthrough. What will produce a breakthrough is death on an industrial scale, frankly. And short of that, it will be incremental and it will not get to the heart of the issue.
Tom, before you come in on that, I want to bring us just for sort of a final round and pick up a couple of questions that are in the chat. And then I think what we've sort of said in a sort of one of the threads has been creating a better conversation between environmentalists and rule of and lawyers and around an understanding around rule of law. There are a couple of questions I'll mention, and then it would be great just to have a final word from both of you on those. The one around the Energy Charter Treaty and is an appeal by civil society for repeal of the Charter Treaty or aspects of it consistent with rule of law, and how do you see that as an engagement by civil society with law? And secondly, around ecocide, clearly there's a huge community of activists and supporters around the ecocide concept, and it's a really vivid example of an interaction between environmentalists and a call to action around a piece of law. So just how do we see those two examples quite differently, and how do we take that forward from this conversation?
Great. I'll deal with the first of those and leave Philippe to the second, but I want to start with where he ended up, because I'm often asked whether I'm optimistic about the future, and what I say is optimism is a function of your temperament, not your analysis. And I think it's always good to have the kind of analysis that Philippe gave as a starting point, and then engage your optimism in figuring out how you move on from there. I think moving on from false ground is a bad idea, because it's not likely to get you where you need to go to. So even if it's a very bleak place with not very many options looking forward, you've still got to look at it. One of the things I think is interesting, and it connects back to something Philippe said very early on about the law as a constraint on behaviors, and he's right about that. But actually what you've got to count into on climate change is there are an enormous amount of opportunity seekers out there who are seeking actually not for reasons to do with a grand vision of what should or shouldn't be happening, but because actually since Paris, the balance of dynamic has shifted much more away from how do you constrain the economy into not using carbon, into how do you take the opportunities of using carbon, of not using carbon. And at the end of the day, human beings better pursuing opportunities than they are at obeying constraints. So I mean, I'm optimistic in that sort of sense. I saw the question on the Energy Charter Treaty. Look, treaties are treaties, they're law. The whole point of democracy is so that you are able to change laws that are either outdated or you disagree with. So I'm completely in favor of people arguing against the Energy Charter Treaty, which is outmoded in its constraints and actually in quite fundamental ways undemocratic. I'm totally in favor of people arguing against that, and I'm completely in favor of governments withdrawing from it. That's your right under any treaty to do that. So I don't think that's a challenge to the rule of law at all.
Thanks, Tom. Philippe.
Can you remind me what the
So I think let's, we're drawing to a close, and I think I'm really interested in your perspective, having engaged on ecocide, and there's a question around, that's a really vivid example of activists and lawyers working together. How do we broaden that conversation out and make that meaningful?
Well, I think each of us must do our bit. I mean, like Tom, actually, I tend to be an optimistic person. In the sense that I do believe that ultimately the course of history is a rules-based one which will eventually, over time, come to fruition, hopefully in a reasonably positive way. Part of my optimism is premised on conversations that I used to have many years ago when I was a young research fellow up at Cambridge University, and I would have lunch occasionally with the professor of English legal history, Sir John Baker, and he'd ask me what I was working on in international law. He was is a curious person, and I would tell him what I was doing, and he'd pause and reflect, and he'd say, yes, Philippe, we had a similar problem in English law in about 1472. It took 270 years to sort out. And that's how international law is. You can't expect for a moment a revolution to take place in 1945, the idea of a rules-based system, individual rights, group rights, and so on and so forth, courts being set up, to be adopted and magically for it to have its impact. It's a long game. The challenge for us on this issue is that we don't have time, and we don't know precisely what the consequences are going to be and who is going to feel them the most. And that is a real concern. One has the sense that, folk in London are going to do rather better on the outcome than folk in Timbuktu, and that is deeply troublesome. So the question is, recognizing that we are in it together, that the consequences are unknown, what more can be done about it? And I suppose each of us does our bit. So when the folks from Stop Ecocide Foundation got in touch in November and said, would you be willing to consider this? I said, yes, because I, like Tom, like you, like everyone I'm assuming who's on this call, wants to do their bit. What was fascinating for me when a newspaper ran that this was originally happening last autumn, I have 3 children and in their 20s, and they're very supportive of what I do, but basically they think it's boring and useless and dull. And I happen to think that what I do is not boring and useless and dull, but they do. And this was the first time when a newspaper ran a story that there's this group that's going to be involved in coming up with a new crime of ecocide, a definition, that all 3 of them wrote a little WhatsApp or text message, I don't remember, and just said, oh, Dad, finally you're doing something useful. And I thought that was interesting. And I think there's a generational thing here. And I think my generation, our generations, must be attentive to what the younger generations really want us to do. And we have to recognize that we have not delivered. We have failed. And we have to listen to that generation. And I think that's where we have to take our cue from. I want to involve that generation more in what we do. And in law, that's difficult because those folk, bright and fabulous and energetic and idealistic as they are, haven't yet integrated into the legal community. So one of the things I'm interested in is how do we channel the energy of that community in the definition, the application and the enforcement of a rules-based system. That's what I'm very interested in, which is part of the reason why I think we have to widen the discussion, and lawyers and international lawyers have to do a better job about mainstreaming and talking to others than ourselves on these issues.
And we have to see climate change as a way of avoiding the lessons of history. Climate change is exactly an issue that we can use, as it were, to drive forward all those improvements, acceleration of the dynamics Philippe was talking about, because it's a problem that people are already experiencing. It's not a future problem. The science is validated in the minds of the public, which is why we saw Extinction Rebellion and Greta Thunberg. The public has got it. What we need to be doing now increasingly is using the fact that the climate is changing and people get it to drive forward the kind of acceleration that Philippe was talking about that's needed in order to improve international processes or domestic processes. So it's turning things on their head and exactly connecting to the younger generation who've got much more stake in the future than either Philippe or I have.
Thank you, Tom and Philippe. We'll draw it to a close. Thanks for everyone who joined, and we'll leave it at that. That we really need to continue this conversation in an accelerated and broadened format. And at E3G we will certainly be doing that, and we'd love to continue to work with you, Philippe, and with many of you on the line. Thank you very, very much to the speakers, to everyone who participated, and look forward to the next conversation. And join some more events at London Climate Action Week.
Thank you, Karla. Thank you, Tom. Great to be with you.
Philippe. Yeah, great. It's good.
Great conversation. Thanks, everyone. Bye-bye.
Bye.